Welcome to the Docketing Excellence webinar series.
Welcome to the Docketing Excellence seminar series, which is sponsored by Black Hills IP and the SLW Institute. Black Hills IP is an accurate, efficient, and cost-effective US-based IP docketing and paralegal service provider. The SLW Institute is an educational group created by the Schwegman, Lundberg, Wussner firm, which aims to provide insightful and useful information to the IP community. For this webinar series, we have pulled together docketing experts and managers from the Schwegman firm, Black Hills IP, and their respective clients and customers to help educate on key docketing challenges and issues and share best practices on how to overcome them. The Docketing Excellence webinar series is free. There are about 2 webinars per month through May 2017. To see a complete list of the webinar topics and to register for future webinars, go to the Webinars tab of the Black Hills IP website, which is www.blackhillsip.com. The webinar that we are presenting today is the 10th in the series. Today's topic is difficult EPO actions to docket. We've allowed time at the end of the webinar for questions. Questions may be submitted by using the Q&A button on the control bar at the bottom of your screen. You can submit a question at any time during the presentation. The question will be held in a queue until the end of the presentation when we take the questions. Before we get started today, I want to announce the Docketing Excellence LinkedIn group that we've recently created. This is a group that is dedicated to giving people an environment where we can continue to discuss topics like we've been discussing on this webinar series and in the seminar that we presented last week in San Jose. So it's very easy to join the group. Just go to the URL docketingexcellence.com. When you enter that website in your web browser, it will automatically redirect you to the sign-up page for the LinkedIn group. So we'd love to have as many people join this group as we can, and we hope to continue some of these discussions and allow people to be able to reach out to other professionals with similar interests and questions through this forum. For today's program, the presenters are myself and Christy Wheeler. I'm Ann McCracken, the president of Black Hills IP. I'm a patent attorney with 20 years experience in patent prosecution. I was a partner at the Schwegman firm for 10 years, and I also was a full-time law professor and directed the patent prosecution program at Franklin Pierce Law Center for 5 years. Christy, can you introduce yourself?
Hi, I'm Christy, and I've been a foreign paralegal for 24 years and have been in practice in the foreign IP or in IP for 29 years. I've worked in law firms only, in small and large law firms. Last 12 years being with the Schwegman firm. So.
Well, thank you, Christy. I'm really happy to have you as part of this program today. Today's topics are going to be broken up into categories based on whether we're talking about a European patent application that came in through a Paris Convention filing at the 12-month deadline off of the priority application, or whether it was based off of a PCT application that went into the EPO as a national phase. Is that right, Christy? National phase application. Get my terminology correct. And then we'll also comment briefly on the publication forms and some observations we want to share about how EPO countries grant patent numbers at the validation stage. So the portion of the program, the main portion of the program, though, will be centered around forms related to EP search reports and notices of publication of search reports, and the timing and forms related to responding to written opinions, things like that. The things that are very tricky and difficult and trip people up often when they are doing docketing for EP. So to get started, we have a chart in your materials. This chart is specific to the scenario of an application being filed in the EP as a convention filing, so filed under the Paris Convention. On the far left side of the chart, you'll see the filing requirements for this type of filing. Then, just as background, the EP convention filing publications happen at 18 months. So the publication of the application itself happens at 18 months. More than likely, you won't get the search report, though, until after that 18-month publication date. The chart that you're looking at on this slide outlines what happens in detail after that 18-month publication of the application. So this chart has 4 different scenarios shown for EP Rule 69 and Rule 70. Rule 69 and Rule 70 both relate to the notification of the publication of the search report, and these can actually come on the same form. Now, there's something really important to note that for quite some time I didn't actually understand myself, and that is that in Europe, the publication of the application is different than the publication of the search report. These are 2 different events in the EP prosecution process. The publication of the search report in particular has docket dates that are triggered from it that can be tricky to docket, and we'll spend some time talking about those. So the scenarios in the chart that you're looking at are based on whether at the time of filing the examination fees and/or the designation fees were paid. So the way you read this chart is you go left to right. The first scenario starts in the box at the top left. In this case, the examination fee was paid and the designation fee was also paid. You can see that in the box in the top left at the time of filing. Then the next block to the right of that shows that the search report issues, and after that the applicant has the option to file a voluntary response. Then the search report itself publishes, and the notification of the publication of the search report is on forms either 1081, 1082, or 1083, depending on the scenario that you are looking at. All 4 of these scenarios trigger a 6-month deadline to be docketed from the search report publication date. Publication of the search report, not the publication of the application. And note that in this case, no 10-day rule applies. Also, the deadline is calculated from the publication date itself, not the mailing date of that form 1082, 1081, 1083. It's calculated from the actual date of publication, and we'll get into that more in detail as we go through our slides. Also, you'll see on the far right there's some red asterisks, and an important one to note is for the second scenario, so that second red asterisk, the lower one of the 2. In that scenario, the examination fee was paid at the time of filing, but the designation fees were not. To speed up the examination by waiving Rule 70, you should ensure that the designation fees are paid when you file the voluntary response. Also note, if you're looking closely, and as most docketers are very detail-oriented, if you're looking at this chart closely, you might see a few typos. This was not a chart we created ourselves, so we weren't able to edit to correct that. So please excuse the couple of typos in the chart. Well, Christy, I'll let you talk about the search reports.
All right. First of all, please note that some of our slides refer to the 10-day rule. And if you attended the previous webinar, you know that there is no such thing as a 10-day grace period. Rather, there is a 10-day notification period that is calculated from the mailing date of the document. The deadline for responding, in this case of search report, is 2 months, and it's calculated from the 10-day notification date. In other words, you add the 10 days at the beginning of the period, not at the end. So it'd be 10 days plus 2 months, or 10 days plus 4 months, whatever your European deadline states. So there's 3 types of search reports. They come on Form 1507. The first one that we're going to discuss is the partial search report, and it's 1507 US, and it can be used for either PCT or PCT, or no, EP or PCT EP applications. In other words, 12-month EP convention or PCT conversions to, or PCT national phases. The applicant is informed only some claims have been searched and 1 or more search fees need to be paid if you want the rest of the claims searched. The deadline is 2 months from notification. And again, the 10-day rule applies. And whether or not you have paid those search fees, a Form 1007N will follow. And so this is an option where you're not going to get any opinions or anything from the search report until you don't have to pay the search fees additional. And if you don't, you'll get an opinion just based on the original search report. So then on the next page, the extended ESR, or the Form 1507N, is including the opinion of the examiner. Once he's figured out we didn't pay additional fees, or all the search included all of the claims in the first place, you're going to get an opinion of the examiner. And you can respond to the search report, but it's not a hard deadline to docket. The hard deadline, again, is based on the publication of the search report, and that does come later. As a caution, some people will docket a soft deadline for possible responding to the search report. If your client sees the search report and wants to respond to it, they can do so before you even receive the publication. And so, as an example, at SLW, we docket a 5 months from the search report date for instructions to agent. Again, this is a soft deadline on our docket, and it also acts as a reminder to check to see if we have received the publication of the search report. Sometimes I've gone in once that comes up on my docket, and I find that the search report has been published, but we haven't been notified of it by the agent. So, you know, it's a good thing to have a soft docket on, just to check if that search report has been published. And then in the third type of search report, it's a 1007W, and this is really a special case where you have asked for accelerated examination through PACE. There is no examination opinion, because you're basing, at that time, no opinion of the examiner is included. An examination report, your Article 94.3 letter, or, you know, some people just call it an office action, or the Rule 71.3, the allowance, will follow. So you're, and again, it's only issued if you request PACE and or waive the Rule 70 communication. So. Here's an example of Form 1507 communication for a partial search report. The deadline, again, for responding is 2 months from the notification date. The notification date, again, is 10 days from the mailing date. And so, in other words, you add 10 days from the mailing date, and then you add 2 months. And if you attended the last webinar, you'll remember that 10 days start from the day after the mailing date, and you do not count the mailing date.
In EP, yes.
In EP, yep. Yeah.
And we talked about some differences in China for that, but definitely in EP. So, Christy, I just wanted to comment on something that I learned as we were preparing for this seminar, and that is the applicant gets the search report prior to the search report actually being published, right? So this form 1507 is the communication that the applicant gets the search report. That's how they get it. But and you ultimately have to respond to the search report, but the deadline for responding is not calculated. Well, you won't know the deadline for responding to that search report until you know when it's going to be published.
Correct.
So you have something to respond to, and this is tricky from a docketing standpoint because you have something that there is a deadline to respond to, but you can't calculate that deadline for responding yet. And that's why you offered the suggestion that I think at the Schwegman firm, they docket what they call kind of a soft deadline for the possible response, just to get that out there and have that on the docket, even though that's not the actual deadline.
Right. How our docketers use it is we call it an instruction to agent. At SLW, we have instructions to agent that appear 1 month before a hard deadline in our foreign matters, and therefore when the docketing team actually sees that the search report has been published, they will go in and change that instructions to agent to the 1 month prior and indicate that we have received the search report publication.
Okay, so they put the soft deadline out there until they're able to calculate, because they can't calculate it. They don't know what it's going to be in the beginning.
Yep.
So then when the form 1081, 1082, or 1083, whichever one applies, the Rule 70 communication basically comes through. That's when they are going to be able to calculate the actual deadline, correct?
Correct.
Okay, so forms 1081, 1082, and 1083 are communications that report the publication date of the search report. This is what the hard deadlines are docketed off of. And I'll show you in a minute an example of what this form looks like, but the publication date shows up in the body of these forms, 1081, 1082, and 1083, and the deadlines that are calculated off of that are calculated from the actual publication date, not the mailing date of the form, which is a thing that's a very common mistake and another thing that's tricky for people who are doing docketing for EP work.
Correct.
So the differences between these forms are Form 1081 is a combined reporting of the publication date of the search report, which sets the exam fee deadline and also the deadline for paying the designation fees and responding to the search report opinion. The 1082 form is used when the exam fee was paid earlier, most likely at the time of filing. The form invites the applicant to confirm that the application is to continue and respond to the ESR opinion. A designation fee reminder is included in case it was not already paid. And the deadline here is a 6-month deadline from the publication date. And also note that the 10-day rule does not apply to this due date. So don't add 10 days before you add the 6 months. Just take 6 months plus, take the mailing date, not the mailing date, sorry, erase that. Take the publication date, which is in the form, and add 6 months. Form 1083, the third version, is used when the exam fee was paid earlier, again, most likely at the time of filing, and a response has already been filed to the search opinion. This form simply informs the applicant of the publication date of the search, and a designation fee reminder is included in case it has not already been paid. So here's an example of a notification of the publication date. This particular one is Form 1081. And by the way, if you're not familiar with these documents, the form numbers on all of these documents are on the bottom of the document, typically in the bottom left corner, and you can see it in very small print on this one, EPO Form 1081 on the bottom left. As you can see in the fourth line of the document, if you include the heading as lines, you go to the fourth line down, the publication date is 4/11/15. Now remember, this is a European document in a European date format, so that publication date is November 4th, 2015. And then your due date would be calculated for docketing purposes as 6 months from that November 4th, 2015 publication date. Okay, so that's those are forms that are specific to the scenario in which the EP application was a convention filing. Now we have a couple forms that we want to discuss which are specific to an EP application that came off of a PCT application. So again, looking at this chart, in the bottom left, you see the kind of shaded boxes. Those are the minimum filing requirements for a PCT, an EP application off of a PCT. And just one thing to notice that's different from the first chart that we looked at in the first filing scenario. In this case, for a EP application off of a PCT, the excess claim fees are not required at the time of filing. You can see that they're not in the minimum requirements shaded boxes, but rather they're just to the right in optional filing requirements, and that's the excess claim fees box. So this chart shows different scenarios depending on whether the International Search Authority was the EPO or not. The chart has 2 pages. The page that we're looking at shows the docketing scenarios for responding to the PCT written opinion and payment of excess claim fees. That is associated with Form 1026AA, 1026BB, and 1026CC. And you can see kind of in the middle of the document the column that has that form number, so then you can map that column or those forms back to the particular scenario on the left, whether it's a non-EP International Search Authority opinion or it's an EP International Search Authority opinion. And then in the case of the EP International Search Authority opinion, there's some different scenarios. So depending on the scenario, different versions of the Form 10226, either AA, BB, or CC apply. And also important to note, look towards the bottom center, or the center bottom of the chart, where you see the 2 blocks for Form 1026AA.
1226.
Or 1226, sorry. Thank you, Christy. 1226AA. It's important to note that in that scenario, the EP was the International Search Authority, and a response to the written opinion has not yet been filed. In that scenario, you can see that the amendments are mandatory. So in the 2 boxes on the bottom right, amendments are mandatory. And also, again, a comment, we got these charts from a European associate that we work with, and you'll notice in some of the boxes VE, and that puzzled me at first until I called my friend and asked him what that meant, and he said, oh, you can ignore it, that's Gaelic. So the VE in the boxes means nothing to us. It's a notation that our European associate had in that box. Now there's a second page to this chart, and really, if we had more space, these 2 pages need to be set side by side. The second page would go on the right side of the first page that we just looked at, and it's an extension of the top scenario in which the searching authority was not the EPO. And this shows docketing scenarios for publication of the search report in that case, and forms 1224, which we will talk about. So, Christy, can you talk to us more about that form 1226?
Yes, this is your Rule 161 and 162. And these are for only PCT EP applications, not for regular EP applications. so national phase is off of PCT. And please note, this is the form for the scenarios with Europe as a international searching authority, and a response to the written opinion was not filed, and then amendments are mandatory. A response to this form within 6 months is mandatory. We're talking about the EPO 1226 AA form. That's where the amendments are mandatory. The 10-day rule does apply to the 6-month deadline, and this form, if no response is filed, the application is withdrawn. So you really need to make a response to that, or the case is dead. So it's a real important date to docket correctly, and understand that it is a mandatory response. So that's your 1226 AA. On the EPO form 1226 BB, the response to this form is voluntary. The application is not withdrawn if you do not respond to it. So it's issued if there's been a negative opinion by the EPO in the search report, and amendments or comments have been filed on regional phase entry. So at the time you sent your national phase, you said, hey, we want to make these comments. A response to this form within 6 months is voluntary. And in other words, the application is not withdrawn if you do not respond. And it's indicated by the wording, you may comment. So the next rule form is 1226 CC. And these are cases where Europe was not the international searching authority, or there was a positive international search report opinion or written opinion. Response to this form is in 6 months, and that, again, the application is not withdrawn if you do not respond. There are 2 types of responses that should be docketed from this: the response to the search opinion and payment of claim fees, excess claim fees, that would be. So if you're going to pay any fees or have any claims over 15, you're going to have to pay those fees. And if you're not going to respond to this written opinion, you still need to review the number of claims and pay any excess fees, or reduce your claims to 15. So those are 2 independent deadlines that must be complied with on a rule or on a form 1226 CC.
And the 10-day rule applies to this one.
Okay. Yeah.
Yep.
Yeah, I saw that. Okay, here's an example of the form 1226 CC on, again, it's a non-EP searching authority. And again, the forms are under that, at the bottom under that registered letter item. So that's just a sample of the form.
Okay. Next is form 1224. This relates to Rule 70. This again is in the context of a PCT national phase application, and this is the version of the form for notification of publication of the search report that's used in the PCT national phase context. So this form is issued after a supplementary ESR. A 6-month mandatory deadline from the date of notification applies. And remember, the date of notification is 10 days from the mailing date, so the 10-day rule comes into play here. You must confirm that the application is to proceed and respond to the supplementary ESR. Note that the communication has two independent deadlines that must be complied with in this response. Those are for Rule 71 and Rule 70A2. And again, the deadline is from the date of notification, so the 10-day rule applies when docketing this one. And this is just an example of the Form 1224.
I just realized that the difference is the two, we talked about two independent deadlines that must be complied with, and we just gave the rules.
Mm-hmm.
One of those is that you intend to proceed with the application. Mm-hmm. And then the other one is that search opinion response. You're responding to that searcher's opinion.
Good,
so,
good. Yeah, we didn't have that in the slides, so yeah. That's good. I'm glad you caught that. Okay, we mentioned at the beginning that the publication of the application is different than the publication of the search report, and we've discussed in detail the search report and the publication of the search report. So, Christy, can you talk a little bit about forms related to the actual publication of the application?
Okay. Well, I'm just going to, the slide is pretty informative. The Form 1133 publication of the EP, Form 1203 publication of the translation of a PCT EP, and Form 1219 and publication of only the biblical data for the PCT, where no translation of the PCT was required. I'm assuming in the United States, the Form 1203 is probably not relative to most of our clients or most of the applicants. We just want to remind you again that in Europe, this publication of the application is separate from the publication of the search report that we've already discussed, and these are totally different things. The only docketed deadline that should be noticed here is your Hong Kong Stage 1 deadline, which would be 6 months from the date of the publication. That's the only date that needs to be
docketed
in your system.
Publication of the application?
Yes.
Okay.
And then we're just going to touch on when the patent grants, you need to go into your validation countries. Again, many of the countries, you need to decide. Usually you like to tell your agent that you're going to go into certain countries when you receive the 71.3, which is your notification that it's going to grant, and you need to approve the text and pay your fees and translate into French and German the claims. But then you have a 3-month period from that grant date in most countries, not all of them, but most countries, you need to have your validations completed in those by that 3-month period. There are some exceptions, but once that patent has granted and you go into certain countries, they do assign a new patent number in it. So if you weren't aware of this, don't worry. Most of your annuities can be paid by referencing the EP patent number. But we just wanted you to be aware that these countries, Germany, Spain, Austria, and Italy, do assign a new number. What you should have is that EP number listed somewhere in your database. Again, your publication number in Europe also becomes your patent number when it grants. So you can have that publication number carry over into your validation countries, and then in Germany, Spain, Austria, and Italy, identify those specific countries. And again, most countries, I believe all these countries will also be able to pay annuities with the EP patent number as well.
That's a great tip. I didn't realize that.
And it also, if you're searching for a specific patent number, you know, then these 4 countries wouldn't come up. But if you search by the publication number and you have it in the validation countries as well, that would be a way to identify those.
That's a good tip. Well, I just want to remind the audience that questions regarding today's webinar can be submitted using the Q&A button on the control bar on your screen. If you have questions regarding Black Hills IP services or processes, please contact our Vice President of Sales, Jim Brophy, and his contact information is listed on this slide. So we've today talked about difficult items to docket in the EPO, and we have a couple of questions here, so let me take a look in our Q&A box. First of all, regarding Rule 70, I believe the deadline is set from the notification of the Rule 70 in a convention or PCT EP entry, but the deadline is triggered by publication of the search report in the divisional EP applications. Christy, is that, I'm thinking about that question here.
That'd be a divisional. I think it would be the same.
For the divisional?
Yeah, because if you're divisional, you're gonna have another search report that would need to be published.
Yeah.
No.
Okay.
I mean, I don't. I'm sure.
Christy's wishing.
I never thought of divisional.
Yeah, we didn't address that, but that's a good question. Let me keep going. Okay, so I've got 3 people asking if the slides will be made available to the attendees, and definitely after we finish the programs, we post the slides and the audio recording on our website at www.blackhillsip.com. Allow us a few days to get those posted to the website, but check back and they will be on the website.
And can we put the answer to that divisional on?
Yeah.
You could add that to the.
We can go back and double check that question on the divisional and send that out to everybody.
I'm sure a divisional would have another search report, which would then be published again. So.
Yeah, we'll double check that and get back to everybody. Okay, back to the questions. Is there a 2-month extension available for the Rule 94? Did we talk about Rule 94?
No, Rule 94 is your office actions.
Okay.
And the first deadline is 4 months, and there is a 2-month extension. So it does go out to 6 months. I do not believe there's a fee for that extension, but you need to advise the agent if you're going to be using it. So yes, there would be.
Okay, thanks, Christy. Let's keep going. Here's one. What is the official publication date of grant? There is often an intent to grant date notified, but not the actual grant date. So what's the grant date, I think is the question, as opposed to the intent to grant? Is there an actual grant date versus an intent to grant date? That's the way I'm reading that. Are you reading it different?
There's a decision of grant that comes within 30 days before the grant date, so that you can get your divisional deadline is based on that.
Mm-hmm.
So that the day before the date of grant is that, and I'm not, where'd that go?
Right here.
So the decision to grant. Yep.
And somebody just responded and said the decision to grant will indicate publication, which is deemed the grant date. It's from that the validation deadline is set.
Yeah. Yep.
Okay, thank you.
So let me see there. What's this one?
That's the one we just looked at.
The intention to grant, that should be the 71.3, I believe.
Okay. Okay, so those are the questions about the grant date. Here's a question, and for those of you that were on the last webinar, we know we had some issues with the audio recording, and the question is, are we still going to re-record that? And actually, yes, John and I are re-recording that on Friday morning this week, and as soon as we've done that and have the materials available, we will notify everybody that they've been re-recorded, so anybody who wants to go back and listen to that will be able to.
Just there's a question that it's the Rule 69 for the EP convention, but if you look at that Rule 69, it also indicates that a Rule 70, they're both Rule 69 and Rule 70 are on the same.
They come on the same form.
They can't come on the same form. Read your Rule 69 that you get. The Rule 70 is mentioned later on in that title.
So oftentimes these EP communications will have more than one deadline associated with them, and those are triggered by more than one rule. And that's this example where you're talking about you could have a Rule 69 deadline and a Rule 70 deadline in the same communication, and that's not unusual in EP communications, right?
Right.
Okay. I think that's it. Oh, wait. I think that's it for questions.
Yeah.
So I just want to remind everybody that we will post the slides on our website.
Here.
Oh, yep.
There's when you receive the Rule 97 decision or grant, would you want to update your system with the grant date or wait?
Oh, that's a great question. When would you do that?
I think ours, I think our docketers put it in when they receive it, but it doesn't generate to issued until that date is passed, or until that date.
Well,
So I mean, you have the information,
right. It's kind of like a issue notification in the U.S. In the U.S., you find out the issue date in most instances prior to the actual issuance of the patent, but the patent office notifies you in advance, and I think the docketers typically will put that date in the system, even though it's in the future.
Right. And no, the one thing though, you know, I kind of go back and forth because we haven't actually got the patent, and what if we pull the issue, pull the patent from issue?
True. And you live more in the foreign world, and I live more in the U.S. world. In the U.S. world, you would address that problem when it came up, oftentimes by removing the docketing information associated with the issue date that you've now withdrawn from, just going back and taking that out, as opposed to not putting it in and then later forgetting to put it in. I think the risk there is you have the information, and if you just hold on to it and you don't put it into the docketing system, then there's a risk that it never gets in, even though it's a date that's in the future. So these are good process questions, and everybody has a little bit different process on how they handle these things, and these are fun to talk about.
Now, this is the number of claims that we allow to file in the EP application. It's 15 claims without any excess fees, but after 15, the price of the claims per claim is, I don't know, about $250 per claim.
It's expensive.
Yeah. So most of the claims can be, because they allow multiple dependent claims or combined claims. So usually you can combine all of your, well, it depends on how many claims you're working with. A lot of the claim sets you can add or have your EP agent suggest claims if you're not familiar with how to add them to get the coverage of all the claim coverage.
Right.
So
right.
You can get away with that.
Okay, so this is a question about validation, and actually we have a seminar or webinar in about a month and a half specific to EP validations, I think, and don't quote me on this, it's on our website, I think it's April 12th. It's in that time frame where we're going to do one specifically about docketing the EP validation process. But This question is for validation countries. What filing date is used?
The PCT filing date. Well,
assuming it was based off of PCT.
Yeah, the EP filing date.
The EP, yep.
Yeah, yeah. You use your EP application number and you use your EP filing date on all of the validation countries, and then the grant.
Okay. All right, that's going.
What's that other? Oh.
So the next webinar in our Docketing Excellence webinar series is on March 1st at 1 p.m. The topic is I'm sorry, that's not the right one. The topic is tricky, and I got the wrong date too. It's March 15th. So the next webinar is March 15th, and the topic is tricky Chinese Patent Office deadlines and procedures. So to register for this webinar, go to the Black Hills IP website. Thank you very much for participating today. We hope you will join us for this and other webinars in the Docketing Excellence webinar series, and that you will join our community in LinkedIn in the Docketing Excellence group. Thank you.